All right, today we're going to talk about parole and adjustment status. It sounds simple, but it is super complicated, and it's important for both family immigration lawyers and business immigration lawyers, okay, or practitioners. So one of the first things is I'm just going to read 245A. What are their basic requirements? Just two. I see a lot of people get this wrong. The applicant must have been inspected and admitted into the United States or inspected and paroled into the United States. Okay, that is right on USCIS's website 245A. We're going to explore in depth what this means and all the contradictions that this involves. So the basic part that everybody should know is if you entered illegally, right? You were smuggled in, you just entered, crossed illegally, entered without inspection, EWI, you cannot just file adjustment of status, generally speaking, because you were not inspected. Inspected or admitted, I mean you came in on a B1, B2 visa, tourist visa, F1 visa, or you were paroled into the US, inspected and paroled, then, well, now you can file for 45 adjustment of status application under 245A. This is where now it gets extremely complicated. You might say, look at all the DACA recipients, right? The Deferred Action Children Arrival people. They were, smuggled in by their parents or somebody. They entered, illegally when they were young, so they were never inspected. How can they file adjustment of status and get a green card? Now, this is pretty much settled now because based on the Arabell decision, if they can get an advanced parole, they leave, they come back, now they're inspected, right? Inspected and paroled. But here's where it's so complicated. Basically, it's this Indian couple that came to the United States, filed for adjustment of status, needed to take care of their parents, so they got an advanced parole, and they left the United States to care for their parents back in India, and then they came back in. But then upon re-entering, upon filing the adjustment of status, suddenly it got denied. Why? Well, because they had various inadmissibility grounds, for example, the 10-year bar, because they were here illegally prior before that, but they were trying to use a 245I. Okay, so Indian couple trying to use 245I, it's a separate thing, we'll talk about that in a different podcast, and they left the United States. And so the issue in that case, getting an advanced parole when they are entering, does that trigger the inadmissibility ground of the permanent bar, or the 3-year or 10-year bar, right? In that decision, legal ninjutsu, they said if you got an advanced parole and you left, that was quote unquote not a departure, therefore no need to be inspected, therefore doesn't trigger, therefore they can still file for adjustment of status. Okay, the dissenting opinion is very funny. Right in the beginning it just said, what does that mean? A departure is not a departure. Advanced parole leaving is not a departure. That completely contradicts what Congress wrote. Now, if that's not confusing enough, how does this apply to DACA recipients? Because if departure is not a departure, then how come when they enter, inspection is not an inspection? You see the funny part? If DACA recipients leaving the country with an advanced parole, quote unquote, did not really depart, when they entered, now somehow they are inspected, meaning logically they did not depart, but they were inspected upon entering, right? So this is like, a ninja move upon a ninja move in legal theory. Whatever the case, and whatever your opinion of it, that is now settled law, and it's good until in 2020, in the matter of ZRZC, applying to a TPS case, in that case, they said, no, if you leave on an advanced parole, you did not leave. It's a status. Now, the plot thickens with the matter of ZRZC in 2020, when an El Salvador TPS recipient got an advanced parole, left the country, came back in, married, filed I-130, now adjustment of status, and in that court decision, they said, because you are a TPS recipient, this affects TPS and then indirectly affects DACA, theoretically, right? It wasn't stated in the opinion, but now your leaving and entry was not inspected and paroled. Basically overturning Arabell. So logically speaking, DACA recipients, TPS recipients, taking advanced parole, leaving the country, coming back in, is not considered inspected or paroled, therefore does not qualify for 240. 245A and therefore cannot adjust status. All right? So that was a crazy case in 2020. Everybody was freaking out. I see AILA memos and emails all over the place wanting to overturn it. And then in July 2022, USCIS rescinded that adopted decision, saying, nope, we're not going to apply that. It goes back to what we were talking about before. So if you filed adjustment of status and then you left the country and you come back in, that's considered inspected and paroled. Do you see how complicated this issue is? All right, so I'm just going to summarize this whole parole concept. For people who want to adjust status in the United States, you first need to be inspected or admitted, inspected, or paroled. Meaning a CBP officer needs to have inspected you and let you in somehow, some way, right? If you are a DACA, if you entered without inspection, right? So you are a DACA recipient, if you are a TPS, if you are in any sort of illegal status in the United States, and then you marry a U.S. citizen or you find a way to adjust status, well, you still need to get inspected. One way to do that is to get an advance parole while you're filing for adjustment of status. But this is where things get complicated, because then if you leave the country, does that trigger inadmissibility issues? Arabell says it doesn't trigger it for the 3-year, 10-year bar. It could trigger it for other particular inadmissibility issues, which is the discretion of CBP officers. That's something you have to be very careful about. And then when you enter back in, under that theory, you didn't depart, but now you are inspected and you can come in. The matter of ZRC said, nope, that doesn't work anymore. And then later on, USCIS changes their mind a couple years later, 2022, saying, okay, it does apply. So this issue is complicated enough for immigration lawyers, let alone the public, let alone ordinary immigration judges. Because what does it mean that the departure is not a departure, yet it can be inspected? This issue is my new favorite example when people ask me, how is immigration law broken? It's broken because of all these different contradictory interpretation of what language means, right? English is not English anymore when it comes to immigration law. So the whole thing needs to be rewritten, and that's a lot of work. And to be fair, immigration law is extremely complicated, and when reading through this policy memorandum of USCIS, you could see they're struggling as well. I mean, all of this is really good people trying to do good things. You know, they're trying to bend the law in a way that can help people but not get in trouble, because the law is the law until Congress changes it. So let's go through this policy memorandum rescinding the matter of ZRC, because you can see how complicated that is, right? They adopted this formal decision, it was formally reasoned out, and then now within 2 years they're rescinding and saying, oops, that was a mistake. But you can see how difficult the situation is. So the reason why matter of ZRC was entered into law, was adopted in the first place, is because TPS beneficiaries returning after authorized travel abroad was made under the provision of the Miscellaneous and Technical Immigration and Naturalization Amendments of 1991, MTINA. Okay, so MTINA created this provision, TPS people, and then DACA is far later in the 2000s, basically saying if you get an advanced parole, it will restore your original status in the United States. So the reasoning goes, well, the TPS people entered the U.S. illegally, typically entered without inspection, same as DACA recipients, they entered without inspection. Well then, if you had filed for advanced parole, it only restores you to the position that you were in before you left the United States. Well, if you entered without inspection and then you advanced for parole, then you still entered without inspection because you were never inspected. You see? And so now this new policy memorandum in 2022 says we will not be giving them advanced parole, but we will give them a special new TPS travel authorized document, which will serve as they have been inspected and admitted. Do you see how complicated USCIS is in having to deal with these different issues? They're looking at it because people are filing for adjustment of status under 245A. if they could just amend 245A and say you could be inspected and paroled, and also if you have DPS, or if you have DACA, then if you change that, then none of this would be an issue. But now they have to bend over backwards to try to get them to be inspected. Well, how can they be inspected? You know, I mean, maybe USCIS should just send an officer to their house and say, hi, I'm just going to inspect you, and then that'll be fine. But USCIS and CBP and immigration law doesn't work that way. They have to leave the country and be inspected by a CBP officer. But in order to do that, who's going to leave? Because if you leave, you cannot come back. Well, you get advanced parole. But is it advanced parole inspection or not? Well, there's other laws that govern. Well, when can you get advanced parole? And what status does that restore you to, right? And so after all of this ordeal, basically now TPS and DACA holders, if you get your advanced parole, you can still leave, get inspected with the CBP, come back in, and now you can still file for adjustment of status. But this is not an easy feat for an ordinary person to understand. It is not an easy feat for USCIS because they're governed and they're bound by the law, and so they can change certain policies to make it work, such as this memorandum. They're going to issue a new travel permit so that they can be inspected. We'll touch upon this later, but like parole in place and other things, you can be quote unquote inspected by a field office USCIS officer without having to leave the country. If USCIS can create a new travel authorization so that people can be inspected, and parole in place, which we'll talk about in a different segment, can be considered inspected if USCIS approves it and you're inspected at a field office, and then you can file for adjustment status, then USCIS, the executive branch, Congress, can totally do that with DACA recipients and TPS. But that is parole and adjustment of status for you in a nutshell. Thank you for listening, and I'll see you in the next session.